And Marshall Chriswell is with us. It's another installment of Martial Law, and this radio program is intended to be for informational purposes only. This information does not constitute legal advice. The law constantly changes. The information may not be complete or correct, depending on the date and your particular legal problem. Each problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of those differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is one of those, and he's with us this morning. Good morning.
Good morning.
It's good to have you with us here today.
Nice to be here.
All right, so we want to talk a little bit about property law, and in particular, something that is known as a landlocked property. If you don't have access to the property, then there's not a whole lot of good that it's doing you. So let's beat that issue around a little bit and find out what we can about it. Describe what a landlocked property is, and then describe how Pennsylvania law treats landlocked properties.
Sure. This is a problem that comes up with some regularity, and so a landlocked property is just what it sounds like. It's a parcel of land that has no legal access, or at least no access that's visible on the ground, or in the deeds of record, in the land records at the courthouse. So it's not it's not adjacent to a public road, and there's no specific express grant of an easement or right of way across a neighboring parcel to get to a public road.
So in order to go to your property, you have to cross over somebody else's.
That's correct.
Okay,
that's correct, and in most cases, at some point, this the neighbors realized that this was an issue. They came to an agreement, and there is an express easement or right-of-way on the record. Mm-hmm. But in some percentage of cases, there is not, and you have a landlocked parcel, and that obviously greatly impacts the value of that parcel, and it's just the practical usability.
It's easy to see how that could occur because of land that is so. I mean, it's 300 years since it was settled by William Penn.
Right.
And so parcels of land, they change character, they change ownership, they get divided up. All kinds of things can happen in the course of 300 years, and all of a sudden somebody is in possession of a piece of property and somebody else has the only way to get to it, somebody else has that piece of property. Mm-hmm. So you said a couple of moments ago they come to an agreement. Sometimes they don't.
That's right, and that's where the problem lies. Maybe you have, maybe you had a situation where neighbors knew one another for a period of time, and you say, okay, well, yeah, if you're gonna get back to your property, you can use my driveway or cross over this field, no problem. Years down the road, you have different owners of one or both parcels, and those new owners don't get along as well. So that happens a lot of time, and so as time goes on, just like with most legal problems, the problems get worse over time.
Yeah, and sometimes those properties that are landlocked end up being public use properties, businesses. There was a famous case here in Indiana within the last 20 years or so of a church and getting access to the new church building after they build a new church, then the road situation there. So how does Pennsylvania law treat this? If somebody has a piece of property and somebody else buys the property next to it but can't get to it, obviously that previous property owner has some rights.
So there used to be, up until between 5 and 10 years ago when the case law started to change, prior to 2010, there was a clear right of relief here. There was a statute. Pennsylvania legislature there was a long-standing statute that was called the Private Road Act, and you could go to a court, you could petition a court and say, "Hey, I've got a landlocked property, and the only reasonable way for me to get access is to cross my neighbor's property to get down to the public highway." Mm-hmm. So you could petition the court the court would generally appoint what's called a board of view, which is some real estate professionals or real estate attorneys. There would be several, and they would actually view the property, look at it, put a value on what that right of way is, and say, okay, if you pay your neighbor X, the court will grant you a right of way to get to your landlocked property. In the past 10, 15 years, 8 to 10 years, this that law came into question, and actually the Pennsylvania Supreme Court, in a couple of decisions, has now basically eviscerated it and said that is an unlawful taking by the government. The government is stepping in and taking a right. This neighboring landowner, he didn't want to have a right of way across his property, and so that's the government stepping in and taking that right from him. It's an illegal taking, and it's an unconstitutional law. So, which you can see both sides of the argument there. But what it's done is, if you're a landlocked property owner, it's really limited the relief that you can get. So, what you've got to rely on then, you've got a few options. Either you come to terms with the neighboring landowner to purchase a right-of-way, purchase an easement over his property, or you look to what's called easements by implication. So even if you don't have an express agreement, something in the land record saying that you have a right to cross that land, there can be other ways to acquire a legal easement. For instance, if you've been using it for 21 years or more. And there are other requirements to that, other legal requirements. But if you've been crossing that land to get with some regularity, consistency to get to your property for 21 years or more, sometimes the court will grant you what's called an easement by prescription, a prescriptive easement. Other ways are, and this is one that can be very helpful if you go back and you have to do a full title search for this, and you see that, okay, my property and my neighbor's property were once part of a larger tract that was subdivided, and it had the same owner. And when it was subdivided, the owner didn't leave an express easement. He actually created this problem. One owner created the problem. Then you can get what's called an easement by necessity. All right. So there are some other options there that you can look to if you go dig back into the property history, and sometimes those rights can be developed over time. But it's tough, and it usually involves some level of court action. It gets expensive, and then you're doing a cost-benefit analysis of, okay, how much is this going to increase the value of the property? Make it more marketable, but how much are we going to spend to get it, and what are the chances of success? Yeah,
and well, that's a really interesting take on it all, because that little historical lesson that you gave us really shows that there are responsible parties, people who can be held responsible for the situation as it occurs. Now, the legislature should have some responsibility here. Have they addressed it since the court struck it down, or didn't really strike it down but gutted it? Have they addressed it at all?
To my knowledge, there haven't been. I know there haven't been any new laws passed addressing landlocked properties, and to my knowledge, there's nothing pending at this time. But I don't know how, given those court decisions, I'm not sure what the answer is there as far as legislation, because the Supreme Court was fairly clear that if the court can't step in and create a property right where one didn't exist and didn't come about by prescription or implication or necessity, where it just doesn't exist at all, and just to come in and say, all right, we're going to slap this easement down on the record and burden this landowner with it. So I'm not sure what the answer is there, but I think it would be a welcome step for a lot of landowners around Pennsylvania if the legislature would think about it.
Seems like they should be able to look at what other states have in place, because probably every law of this nature has been examined by the courts in whatever state it was, and they've made decisions, and maybe something could be fashioned there. But in the meantime, when you are in this situation, this is a complicated thing. And it's not something you want to take on by yourself. You need to get yourself an attorney who's going to be able to do all of the research needed in order to try to find an amicable. You want an amicable solution with neighbors, and so you're going to have to have help to do that.
Yeah, two things there. Like you said, with neighbors, some of, and I think I've said this before, some of the nastiest and just most difficult disputes that I deal with in my practice are neighbor disputes. Sometimes worse than there are other kinds of cases that can get very emotional, and child custody and divorce come to mind. Those can be very emotional types. But sometimes neighbor disputes are even worse because you have people that can't get away from each other. If you don't like your ex-spouse, you can move to the next town over. But anyway, so there's that. But also, like you said, the complexity of it. Digging back into, I can tell you I was dealing with an issue like this last week, and I'm digging through deeds back from the 1860s where they're handwritten, and you're trying to discern, okay, what was written, what does it say? Just trying to read the handwriting, and the quality is not that great. And then also, how would courts interpret and construct the language of that easement today? And so it is very complex. And it requires a lot of research. It's time intensive, and you really have to have the knowledge of what you're looking at.
Yeah, that's not something you want to tackle by yourself.
No.
You need an attorney to help you through that situation. And I would guess that it gets even more complicated as people decide, well, I don't want just the gravel dirt lane going back to my property. Now I want landscaping. I want to pave it. The very many different issues that come up with what kind of access, let alone having the access.
What is the scope of that easement, and what can you do with it? How far can you take it to the line where you then you're actually imposing upon the neighbor and creating an additional burden for him or her that wasn't envisioned in the language of the easement when it was drafted.
I especially think of farmers who might have parceled off land, or somebody else has parceled off land, and now they've got pasture fields where they have to take their cows across what has become a road now.
Sure.
So those sorts of things, yeah.
Sure, or you had an easement that is on the record, just for and whenever it was placed on the record, the only thing that adjacent property was used for was maybe to do some timbering, or somebody would do some camping back there or something, and all of a sudden somebody wants to build a house and use it for, or wants to build an office building and start using that for daily commercial traffic. Is that within the scope of what was, and you have to look at the language and interpret it.
A lot of research, and it requires a very good mind that's going to actually be able to break down the issues. So that being the case, somebody wants to get in touch with you about one of these cases. I don't know if you want that one of those cases. It'll give you a headache, but obviously these are things that need attention. So what do they need to do?
You can give me a call at 724-465-5826. Stop in and see us in the Atrium Building, downtown Indiana, or online at westernpalawyer.com.
There you go. Thank you, sir.
Thanks, Todd.